video. I'm Jason Romney. We're in Sydney, Australia, and we're in the offices of Gilbert and Tobin, where senior partner Peter Leonard has agreed to talk with us about some of the burning legal issues around the cyber life. Peter, welcome to the show.
Thank you, Jason.
Peter, one of the big issues at the moment is peer-to-peer networks and music and movie pirating. There's even a suggestion that using the iPod at all in Australia is illegal, which pops up from time to time in the Financial Review. Is there an anomalous situation in Australia?
I think it's probably fair to say that each country's copyright laws have particular quirks, and the Australian copyright law is having difficulty coping with iPods and the way in which iPods are used today. It seems fairly clear that the use of iPods for what's called format shifting, for people ripping content from CDs for use, even for personal use, on an iPod is a breach of copyright in Australia. By contrast, the use of an iPod for listening to content that is downloaded from legitimate sites such as the iTunes Store or in Australia the Telstra Big Pond music site is permitted. So you have iPods used for a combination of permitted and non-permitted uses from a copyright viewpoint. And I think still with many users of iPods assuming that so long as they're only ripping from their own CDs and using for personal use, that is not an infringement of copyright. In fact, it is, although it's probably fair to say that the record companies in Australia have not seen it as an area of particular concern or enforcement priority, their focus instead being commercial use, commercial availability of content that has not been properly licensed for iPod use.
It is a somewhat sorry testament to the state of online maturity in Australia that we don't have something like an Apple iTunes store here yet. What would you surmise are the business or legal barriers?
Look, I think it's probably just around the corner. In terms of the copyright licenses that are needed to run an iTunes store, they're really no different to the licenses that Telstra needed to get Big Pond music established. So I imagine it's just a commercial issue at the moment as between Apple and the record companies and other licensing authorities over getting the store established. But Big Pond Music is there and running legally, and I understand doing very well today.
Well, of course, when someone buys something online, they're making what they hope is a secure transaction which can't be intercepted by some evil-doing interloper. But the whole issue of security online has come into question with phenomena like identity theft. What is the latest state of play there from a legal viewpoint?
It's an interesting area because the law for a long time lagged behind the activity of various evildoers, and it was really only in the last 4 or 5 years in Australia that cybercrime legislation properly addressed and created criminal offences in relation to unauthorised use of identity. Of course, the problem nowadays is that although the criminal offences are on the statute book, that's not a lot of help for the average individual who has their identity stolen and used to strip money out of their account or for otherwise nefarious purposes. So criminal law is all very well, but it doesn't help you if you're out of pocket. The issue has not been of high priority, I think, to most users because certainly the banks in Australia seem to have had a policy to date of making good any unauthorised transactions that have taken place electronically through identity theft.
I think they're rubbing their hands together with glee over the new fees they can charge from online banking, so they want confidence to be maintained in their online activities, despite the phishing attacks and so forth.
I think it's even more than that. If you look at the figures at the comparative cost for a bank of servicing an over-the-counter transaction to servicing an online transaction, there's a big financial incentive, a big cost-saving incentive for banks to move transactions online as much as possible. So banks have a real interest in their customers being confident to deal online, and if that means in some situations the bank's absorbing some losses that might arise through an inadvertent action by a customer which facilitates an identity theft, such as a customer responding to a phishing email in an ill-advised manner, the banks seem to be, for the moment, coming to the party and making good the customers. And indeed, I'm only aware of one case that's been reported in the United States where a customer has sued the bank after a bank refused to make good the customer for an unauthorised withdrawal from the customer's account. And I think the fact that there's only been one reported case is an indication that there have been, of course, many cases of successful phishing attacks. And the fact that there's been so little litigation is a reflection that banks generally have come to the party in order to protect consumer confidence in online transactions. Of course, one of the big issues is at what point will the bank's patience run thin? Is there a time at which phishing attacks so overwhelm the system that the banks are no longer prepared to make good those losses? And that's the point at which the rubber will really hit the road, when these sorts of disputes may become at a level where the customers point to their terms and conditions and say to customers, well, you weren't careful enough in giving out your details. You should have identified that email as a phishing email and not given out your details. And that's the point at which life will become more complicated.
Is there a feeling that things like digital certificates can actually alleviate these problems, or is the integrity of even those sorts of measures now impugned?
I think there's a view within the banks that there are technological means that could be used to reduce phishing attacks, that many of the attacks that have happened to date have been, however, at a lower level of customers really doing silly things, frankly, in responding to phishing emails that better customer education may have avoided. So the bank's first round of defence is to improve customer education as to what phishing is, and to try and ensure that customers don't give out their details to phishers. And the second level then is to look at technological means such as digital signatures. I know from the discussions I've had with security companies that the cost of implementation in banking environments can be quite high, because many bank online systems are now legacy systems, and to re-engineer those systems to incorporate digital signatures is quite an expensive retooling for the banks. So there are cost barriers, and as I say, banks in the first instance are looking for education of customers to defend against phishing.
Meanwhile, our well-established, almost old friend, the online chat forum, is popping up in areas like mobile phones now that have 3G opportunities for interaction, not just text-based but even video-based. Has the law changed there significantly? There was a recent example of a chat session on a mobile service actually needing to be shut down. What was that all about?
Well, this is an area of great concern to the mobile operators, because many mobile operators have built their business cases for the next few years, including for 3G mobile networks. around increased use of mobile phones in online chat forums and other applications where there's a lot more user-to-user contact, where it's not content that is defined by the mobile operator. And of course, wherever there is the possibility of user-to-user contact combined with mobility, there is the danger that mobile phones will be used by pedophiles and others for illegal and very dangerous activities, potentially involving young kids, because many young kids use mobile phones and are susceptible to approaches in chat rooms where they might not think that the person approaching them is someone other than who they appear to be. So it's an issue of really quite significant concern as a child protection issue. And then balanced against that is the desire to facilitate legitimate chat activity and incredible ingenuity of different groups of the public in using chat forums. So there's mobile chat forums around cricket, local cricket clubs, all sorts of odd and highly specialised groups are looking to set up chat forums, and it has as a result become almost impossible for mobile operators to monitor in any real sense the activity in many chat rooms. I've heard estimates of several thousand chat rooms on some mobile networks around the world. So clearly the mobile operator can't monitor everything that's going on in several thousand chat rooms. So what do you do? Well, the response, again, is a combination of education. It can be a use of technology, such as facilitating quick exit from chat rooms by single button exit, so that if somebody is aware that there's a problem, that they can get out. Facilitating quick reporting, electronic monitoring of what is being said in chat rooms, so that if particular words are used, for example, that flags a potential problem and brings it to a human monitor within the mobile operator. Restrictions as to adult content chat rooms, so that it's necessary for a user to identify how old they are and go through age verification procedures before they can get into an adult chat room. That is a chat room that is advertised on the basis of it having adult content, maybe a dating service, whatever. So there are various ways in which mobile operators, through self-regulation, through technological measures, through age verification procedures, are looking to provide assurance to mobile users that they can safely use mobile chat rooms. Meanwhile, there's a lot of political interest in this area that will have the result that if there is not quick and effective industry self-regulatory activity, the operators can expect that the government will legislate to restrict the operation of chat rooms. And indeed in some overseas countries, in Japan, for example, there's recently been quite heavy-handed regulatory responses to limit the use of mobile chat rooms. So it's an area of quite significant concern in all countries, and there's a happy coincidence, I suppose, for the moment, that the mobile operators are trying to encourage greater use of mobile phones for other than one-to-one calling. So they're encouraging the use of chat rooms, and they're very conscious that if they don't properly regulate the ways in which chat rooms are used, the government will intervene, and certainly the tabloid press keeps a very healthy or prurient interest, depending on your point of view, in any problem that happens in a chat room.
Changing the subject a bit to the issue of regulation and the thinking that Helen Coonan is doing now about all the DVB-H type of bandwidth and how that's going to be disported, do you think that the market can look after itself, as evidenced by something like this shrewd deal between Unwired and Austar, or do you think that there's really a lot the government still needs to do, and do smartly, to control bandwidth and make sure that it's used in an efficient and optimal manner in Australia?
It's a really interesting question, Jason, and it's a hard question to answer in Australia because you always have in Australia the questions of parity between people in remote areas and the cities, and how to ensure adequate broadband access in the bush. And to use the example of Austar and Unwired, some of your listeners, viewers might not be aware that what that deal involved was a provider of wireless broadband in the city doing a deal with a provider of pay TV services in the country, whereby the provider of pay TV services in the country got access to spectrum to enable them to provide wireless broadband in the country, and also to resell in the country the service of Unwired as provided in the city. So it has the advantage for both country and city people. For city people, there's a roaming possibility, so their wireless broadband that formerly only worked in the cities, they can take to the farm or their holiday house and have access there, courtesy of Austar. And conversely, Austar gets access to spectrum to provide wireless broadband services in the bush. It looks like a win for both the city and the bush. And that win was facilitated in Australia through the free tradability of spectrum, in that Austar could sell its spectrum and Unwired could buy spectrum without any regulatory approvals being necessary, without any restrictions through the terms of radio communications licences. The problem, of course, is that when you have these types of innovative commercial arrangements that are possible, sometimes they need regulatory assistance in order to make them commercially possible. And one possibility, for example, one possible barrier that Austar might face is if, as it starts to roll out wireless broadband services in particular country towns, Telstra elected to reduce its pricing in those country towns but leave its pricing for DSL-based wireline broadband in other country towns at relatively high levels. And then you have a regulatory question of whether there should be a regulatory restriction on selective discounting by the wireline provider in order to meet wireless competition. They're the kinds of issues that are going to come up in the next few years as competition in broadband spreads to the bush. And it'll get more complicated as well, because someone like Austar might elect to create innovative bundles of pay TV services and wireless broadband access, and maybe using those to compete against someone who sells wireline services only. The same sorts of competition issues have been arising in the city with the kind of bundling we've seen of cable TV services and wired broadband services. So I think it's likely that we will continue to see competition law issues as innovative service bundles and new types of services become available. Thankfully, in Australia, we have relatively light-handed communications regulation, and as a result of that, there generally aren't many regulatory barriers to people providing new services. The main issues which come up are those types of competition issues which I've just described, and the question then is, how far and how often should our competition regulator intervene to assist new entrants? And that's always a difficult question.
It's interesting that the new All-Star set-top box, which will be their implementation of the Foxtel IQ digital video recorder box, is apparently going to also have a terrestrial DVB tuner in it, so that people can also get the commercial free-to-air television stations broadcasts. The Foxtel IQ box hasn't really been the big threat to the business models of the digital terrestrial transmitters that everyone thought it might be. When you look into your crystal ball, what do you see for the Australian media?
Free-to-air television is still a very interesting business, and what makes free-to-air television an interesting business is its ability to engage a broad spectrum of the population at any point of time, and in particular at prime time. And so long as people continue to look to free-to-air television as their primary source of news, or so long as people around the water cooler want to talk about Desperate Housewives and want to be part of the conversation about Desperate Housewives, free-to-air television will have a viable business case and will therefore be able to attract advertisers and make real money. Now the question, I suppose, then becomes, in the longer term, will free-to-air television audiences erode to the extent that it no longer is the attractive business proposition for advertisers, that advertisers then try to find much more specialised advertising outlets where they can target their particular end users or targets. And an example is the recent BMW films, where famous directors did films for BMW that were marketed on a highly targeted basis. And I think that the answer is that the erosion of the customer base of free-to-air television will continue, but it will continue slowly. And so long as free-to-air television is the easiest place to hit a broad spread of the public, that broad spread of the public that want to tune into the news or Desperate Housewives, that it will remain a very attractive commercial proposition. So I don't think that I would be selling my shares in commercial television stations in Australia or elsewhere for the foreseeable future.
Final question, Peter. There's a lot of dissatisfaction about the speed at which things like ADSL2 are being rolled out. Do you think that that's important for Australia?
I think that the very slow rollout of true broadband in Australia up until about 18 months ago was a major concern. And Australia really lagged badly behind most OECD countries. Really until the last 18 months. Since then, the take-up has been remarkable, and that take-up is of broadband services of a variety of quality in terms of download speeds, but all of which are a significant improvement over the narrowband services that people have come from. I think that over the next couple of years in Australia, the really interesting possibilities are around wireless, given the limited spread of cable services, and also through the new DSL implementations. Although I think that the capital costs associated with the rollout of new generations of DSL will constrain DSL against wireless broadband. So I think that there are technological alternatives that are in the market now that will continue to create interesting possibilities. I think wireless broadband is probably underrated. at present, and I would expect that we will continue to see significant increases in take-up rates of broadband over the next couple of years, to the point where I would expect that Australia will rapidly catch up with the leading OECD countries on broadband usage.
In that framework, what do you see as the most lucrative legal issues coming up?
Often the legal issues around the online space are around the building of the networks and the content platforms that enable these new services to be provided. And the really interesting deals, frankly, from the lawyer's point of view, are the building of the networks and the provisioning of the services, rather than the kind of disputes that capture the public imagination. There are cases like Kazaa and Grokster and the BitTorrent that come along that are fabulously interesting cases and test the limits of copyright law, and other cases that come up with things like framing or use of hyperlinks that test the limits of trademark law or law against misleading and deceptive conduct. But frankly, it's very difficult to earn a living as a lawyer off those unusual cases because they come up relatively rarely. The really interesting things for lawyers are, for many people, very boring things. They are about building new networks and building new services. And I think we'll continue to see a lot of that activity over the next few years. The deal that we saw recently that you referred to before between Ozstar and Unwired is an example of the kind of unusual deals that are coming along now that are of particular interest to lawyers and that test business models and that require new ways of thinking through how to do deals. So there will continue to be deals like that. You can't anticipate what they'll look like in 2 or 3 years' time, but there's going to be plenty of work for lawyers in this space for the time to come.
Peter Leonard, thank you very much for coming on Net Video today.
Pleasure.